Thus, under 64(1)(e), it is something which is nothing new. Now, my lords, your lordships have time and...
Only on an injunction.
Yes, my lords, I'm just giving some background because it was some significance.
Two courts have...
I have, my lords, for 13 months...
Not inclined.
My lords, for
You are not
13 months, my lords, we have enjoyed a stay in this matter. My lords, today, may I just... No, my lords, may I just...
Wrongly.
No, my lords, may I...
So we have launched the
That's why
project
we,
anyway.
that's the less we speak, the better.
My lords, may I at least... I need to at least...
No. Of course, you are entitled to make your argument.
My lords, your lordships have time and again said that merely because a patent is covered by a genus patent is not the same thing as disclosure. Coverage is of millions of compounds. You have certain identified compounds in them. But a particular unidentified compound, which with detailed research later on leads to a drug, is maybe covered but not disclosed. And even in Novartis, the Supreme Court has only cautioned that let the coverage between the two, let the gap between the two not be too wide, but it's not that there cannot be gap between the two. Now, my lords, your lordships, right from the Court of Appeals in England have held that suppose a leaf, and that was the example taken in the Court of Appeals, that a leaf is there in the Sherwood forest. It may be covered, but till someone finds that leaf and identifies its property, it's not disclosed thereafter. So, my lords, exactly that is what happened here. A particular compound, which now by reverse engineering, they are saying, goes back to the original genus, was covered by the genus patent.
Against Indian industry, yeah.
Please, my lords.
Anyway, that's a standard. Reverse engineering is a standard allegation.
Right. But, my lords, the fact remains is that after all, when people do spend millions, it's very easy, my lords, to bring in the public interest element. But please see, we have cooperated, give millions of drugs free. We participated in the national rare drug policy of the government of India. This very drug, my lords, under that came till the Supreme Court, and my lord, the Chief Justice, in a sealed cover, saw the documents and said, Roche has been helping public in this country at very reasonable prices. So that was something which was done.
Let's not get into that.
Yeah, but all that I'm saying is, my lords, today to use a public interest argument to defeat a right which I have under the Patents Act just because you claim that yours is a cheaper drug. My lords, you are also you are driven by profits today.
So interim, concurrent. We are, the way we are looking.
My lords, all that I'm saying is this is an issue which at least requires your lordship's consideration. My lords, for the same, my lords, maybe.
It's an interim injunction.
My lords, maybe it's an interim injunction.
The govern injunction is a very, very different.
My lords, the problem.
Have taken.
My lords, the problem. Right, but my lords, your lordships have also said that there, of course, there are cases where their concurrent findings, your lordships will not interfere. But there are cases which your lordships have also interfered.
Of course.
It's not that your lordships have not. So if I can at least endeavor to show to your lordships that on the bare reading of the first principles of genus versus species and the statutory provisions, my lords, this injunction could not...
Sufficient protection.
My lords, may I with respect say, my lords, today I have protection in over 60 countries for both species and genus. Today, what is being done is, by a counter claim, you introduce a particular theory of bioisoterism. And that is relied on, my lords, to say that we should not get the protection in this matter. My lords, what will happen? They will launch that completely destroys the
already. What do you
Just a minute, please don't interrupt. Till yesterday, at least as per us, you had not launched. And for 13 months, you had not launched. We had done all searches. So you're saying you launched is not enough. All that I am respectfully submitting, my lords, is this, that after all, we've also got a valid protection and patent rights after huge amount of research and investment. Today, my lords, if a wrong principle is applied and that injunction is refused, where do we go, my lords, in the matter? At least consider this matter, my lords.
Thank you.
All that I'm saying is today not pass in order, but consider the matter at least, my lords.
Not necessary.
Wrong principle has been
My lords, the wrong principle has been laid down, would your lordships, that itself would have a far-reaching impact. My lords, may I only say one thing?
At this stage.
And I'll only say one thing and I'll leave it at that. I know your lordships have indicated. My lords, there is a standard test in the statute and various judgments that your lordships have time and again emphasized, and which is a person ordinarily skilled in the art, posita. Your lordships have always said so. From his point of view, inventiveness should be seen. Obviousness should be seen. My lords, the test picked up in this matter is a test to say that because the inventors of the genus were similar to the inventors in the species, thus they ought to have known. That's not the test. The test is of a person skilled in the art, not a person in the know of things. But we are introducing tests into the statute.
We are not inclined to interfere with the order passed by the High Court for the reason that it is interim in nature and the findings are and also that the findings are concurrent. You are not expressing, we have not
May
expressed
I
any
only say one
opinion
thing,
on the
my
merits
lord?
of the matter.
The matter will go on uninfluenced, my lords, your lordship. Lordships may say so.
See, what happens is that as you have done just now, you argue so much on the merits and compel a court to get into it and then reject it if they are not inclined with you. Then in which case to say that all this will not get
My lords, at least
influenced.
at the
So
trial.
obviously,
My lords, but at least if
it
your
is
lordship
obvious,
indicate and then
obvious.
maintain accounts, my
Yeah,
lord.
sure, man, it was your appeal that you have argued before.
Yes,
the High
my lords, all
Court.
the time saying.
And
is
you have opened up on the merits and then you made your
My
submission
lords, all the time,
compelling the
I've
court
opened up on the merits because the court went into merits, my lords.
that
saying
it went because of your appeal.
No, my lords, may I with
We are
this
not-
right? The
we are not-
single judge also went into merits, my
All
lord.
right, needless to say, nevertheless, needless to say that the observations made in the, it's a CMA, what is it called?
My lord, in the interlocutory application.
No, the High Court's jurisdiction is a revisional,
FAO.
appeal against order.
Please. Commercial appeal.
Means civil application are intended only for disposing of the appeal and not, will have no bearing on the merits of the matter.
And lordships, accounts will be maintained by them, my lords, in the matter.
That you apply, that's already there. Thank
My
you.
lords, and let them at least not export,
No,
my
no.
lords, in the meantime.
Thanks.
My lords, because we have patents and other
Commerciality.
things also.
No, Mr. Kaul.
Very well, my lords, I won't say anything more except for at least let them maintain accounts, my lords, in the
Of
matter.
course, we are
Why
duty
asking
bound.
us? Go to the High Court.
Let them, no,
We are
I
duty
have
bound.
to, because
There is a direction. Sorry,
My lords,
there's a
let-
direction.
They will
We are
maintain
duty-
accounts in the matter at least.
Whatever the direction has been.
No,
They will.
no, my lords, would you?
Why didn't you ask this here, there? We are just not interfering, that's it.
Huh? My lords, would your lordships, lastly, and I end with it, would your lordships only consider observing the suit will be expedited, the hearing? My lords, that will have some bearing on our right.
Delhi High Court, we don't know how the board is.
But my lords, some expedition. That's all that I'm saying.
The High Court shall endeavor to dispose of the suit expeditiously.
Very grateful, my lord. Very, very grateful.